June 25th, 2025. As protests commemorating those who lost their lives last year grip the country, a directive from the Communications Authority lands in newsrooms nationwide, abrupt, chilling, and flatly unconstitutional. This is therefore to direct all television and radio stations to stop any live coverage of the demonstrations forthwith. Failure to abide by this directive will result in regulatory action as stipulated in the Kenya Information and Communication Act 1998. As far back as November 2024, the High Court had already stripped the Communications Authority of any authority to regulate broadcast content. According to Justice Lawrence Mugambe, the Communications Authority does not have the constitutional or statutory mandate to control broadcast content. That power lies solely with the Media Council of Kenya. In a landmark ruling delivered on November 12, 2024, Justice Mugambe nullified key sections of the Kenya Information and Communications Broadcasting Regulations of 2009. He ruled that these laws gave the Communications Authority illegal control over content, violating Article 34 of the Constitution, which guarantees media freedom. 6 months later, on May 15, 2025, the Media Council unveiled its own broadcast code, focusing on protecting children, ethical journalism, and content accountability. From that point forward, it was clear content oversight had been legally and institutionally transferred. Yet today, the Communications Authority, under Director General David Mugonyi, issued an order it has no legal basis to enforce. An order that flies in the face of a High Court judgment and directly undermines both judicial authority and constitutional freedoms. According to Senior Counsel Paul Muite, media live coverage of the ongoing peaceful demonstrations pursuant to Media Freedom Article 34 is not incitement to violence. Kenyans not in the demonstrations need to be kept fully abreast by the media through live coverage of the goings-on. Former Chief Justice Dr. Willie Mutunga says, where's the evidence that those provisions have been breached? What about Article 37 and the robust jurisprudence that decrees how the Constitution is to be interpreted? The Communications Authority of Kenya thinks our Constitution allows this fascist interpretive approach. The Media Sector Working Group has condemned the Communications Authority of Kenya's directive to suspend live coverage of ongoing Gen Z protests, terming it unconstitutional and a violation of a 2024 High Court ruling. The group is urging all media houses to defy the directive, continue broadcasting live protest coverage without fear, and exercise their editorial independence in line with the Constitution. They also warned against any attempts to disrupt internet access, terming it a violation of fundamental rights to expression and information. The Kenya Editors Guild further issued 5 demands. Immediate withdrawal. Communication Authority must rescind the illegal directive without delay. Respect of judicial orders. The 2023 court orders remain valid and must be obeyed. Protect the public's right to know. Live coverage ensures accountability, transparency, and public trust. Support independent journalism. Media houses should stand firm, report truthfully, and seek immediate legal protection if threatened. Oversight and reform. Parliament and the judiciary must investigate Communication Authority's conduct and enforce compliance with the Constitution. This isn't just about a directive, it's about defiance. A communications regulator ignoring the courts, rewriting its powers, and threatening the very freedoms enshrined in the Constitution. David Kagina, K24 TV.